what is trademark? The trademark is a distinctive sign, logo, name, word, phrase, symbol, or design that identifies and distinguishes the goods or services of one trader from those of others in the market. Definition given in section 2 subsection 1 clause ZB of the Trademarks Act 1999 defines that trademark means a mark capable of being represented graphically and capable of distinguishing the goods or services of one person from those of others. It may include the word, logo, symbol, sound, example for Nokia tone, and shape the Coca-Cola bottle like this. What are the objectives of or purpose of the trademark? Objective is to indicate the origin of the goods and services, to assure the quality and consistency, to protect consumer interest and avoid confusion, to create brand value and goodwill. The types of trademarks, there are certain types of trademark. One, product marks, service marks. What product marks? And then product marks, service mark, collective marks, certification marks, shape marks, sound marks, and color or smell marks. Product marks used on goods to identify the manufacturer or the producer, LG Electronics. Service marks used for services instead of goods, Air India Airlines. Collective marks used by members of an association to identify affiliation, CA by ICAI. Certification marks given by certifying authority for standard, origin or quality, ISI marks and egg mark. Shape marks, protection given to shape of goods or packaging, Coca-Cola bottle. Sound marks, sound associated uniquely with a brand, Yahoo, Yodel and Nokia. Color or smell marks, rarely color combinations or specific smells may be registered, Cadbury Purple, UK. The important case laws on trademark is Cadila Healthcare Limited versus Cadila Pharmaceuticals Limited, 2015 SCC 73. Issue the similarity between the two drugs names Falsigo and Falsitab. High Court decision says the Supreme Court laid down the test for deceptive similarity, especially in public health. Significance protection says protection extends to phonetically similar marks. Now, if I go in detail, the Cadila Healthcare Limited versus Cadila Pharmaceutical Limited, 2001 and 5 SCC 73. The facts of the case is that Cadila Healthcare Limited and Cadila Pharmaceutical Limited were two companies using the similar brand names for medicinal products. The plaintiff marketed a drug under the name Falsida. The defendant marked a drug under the name Falsigo. Both drugs were used for treatment of falciparum malaria, but they had different compositions. The plaintiff alleged the passing off due to deceptive similarity in drugs name. Issue is what test should be applied to determine the deceptive similarity in case of medicinal products, whether the phonetic similarity of drug names can cause the confusions and public harm, whether stricter standard apply to trademarks used for pharmaceutical goods. Decision is the Supreme Court held that in case of involving the medicinal products, a higher degree of care must be applied. Even phonetic similarity can be dangerous due to risks of wrong medications. Possibility of confusions among the doctors, chemists and patients, including the illiterate or semi-illiterate persons. The court laid down the specific factors to be considered in pharmaceutical trademark disputes. The matter was remanded for reconsideration applying the correct principles. So legal principles laid down in this case for medicinal products, public interest overrides the commercial interest. Stricter scrutiny is required than for ordinary consumer goods. The passing off can occur even if drugs are sold under prescription. So this is the procedure, this is the case law in detail, Cadila Healthcare Limited versus Cadila Pharmaceutical Limited. Now, Daimler-Benz versus Daimler-Benz Acti Agesil Chaps versus Haibo Hindustan. In this case, the issue is use of the name Benz for underwear. The court held even if the products are different, if the mark is globally reputed, its use is in a infringement. Significance protections of well-known marks should be there, should be protected. So well-known marks they are there. So use of the name bench for underwear. Even if the products are different, if the mark is globally reputed, its use is infringement. Protections of well-known marks should be there. So if I go in detail, Delmark bench, Acti Egg Shaft versus Haibo Hindustan AR1994 Del 239. Fact is, Daimler Benz, the manufacturer of the Mercedes Benz cars, owned a well-known trademark Benz. Haibo Hindustan used the mark Benz for selling undergarments. So Daimler Benz filed a suit against the trademark infringement and passing off issue whether the famous trademark can be used for unrelated goods, whether regulations of well-known mark extends beyond this product category, whether such use amounts to dilutions of the trademark. Then the decisions of the Supreme Court, Delhi High Court, not Supreme Court, Delhi High Court held that the Benz is a world famous and well-known trademark. Use of the mark by the defendant was a dishonest and malified intention. Even if the goods are unrelated, such causes the loss of exclusivity and the dilutions of brand value. The defendant was restrained by injunction from using the mark. So legal principle laid down that well-known trademarks enjoy the trans-border and cross-class protection. Trademark law protects the reputations, brand integrity and consumer trust. No one is allowed to trade upon another's goodwill. So this is the case laws of the Daimler Benz Acti Shaft versus Haibo Hindustan AR1994 Del 239. Now, what are the distinctions between the trademark and the property mark? Trademark, the definition and legal law applicable definition: trademark is mark used to distinguish goods, service or business, and property mark used to show the ownership of the movable property. Law applicable in case of Trademark Act 1999, and in property marks Indian Penal Code section 479 and 481 is applicable. Purpose is commercial identification purpose and protection from the theft or misuse. Example: the Tata logo on a car and engraving the XYZ Private Limited on machinery. Legal right is civil plus criminal remedy under the Trademark Act and criminal offence under the IPC, Indian Penal Code. In case of trademark, the duration is 10 years, then renewable, and in case of copyright, no fixed duration. Though there is no fixed duration. So these trademarks are commercial identity shield. They not only protect the creator's brand image and goodwill, but also safeguard the consumer trust. The Trademark 1999 provides for registration, enforcement, and remedy in case of infringement, while distinguishing it from the property marks, which are governed under IPC for property protection, not trade. Section 2(1) ZB, collective marks and reservation mark, Cadilla case, and well-known marks, property marks. This is the short form of a division. 2(1) ZB definition given in the 10 marks are collective marks. Then the upper product mark, collective mark, products mark, services mark, collective mark, services marks is also there. Cadilla case, the Cadilla Healthcare Limited versus Cadilla Pharmaceutical Limited, and the Daimler Benz Acti Shaft versus the Haibo Hindustan 1994 and Delhi 239 AIR 1994 Delhi 239. Delhi High Court has given that the image is world famous and well known trademark and it should not be used.